I'm Ben Meiselas from the MeidasTouch Network. The special master, Judge Raymond Dearie, who is overseeing a review of the records in connection with the case brought by Donald Trump, where Trump stole thousands of government records and then got Judge Aileen to interfere with the Department of Justice's investigation and appointed the special master. Well, Judge Raymond Dearie just issued an order directing the parties, the Department of Justice, as well as Donald Trump through his lawyers, to answer a number of questions. I'm going to read for you what the order asks the parties to answer, but I want to tell you what this is all about. There was supposed to be a hearing that takes place on December 1, where the parties were going to go over their review process to date. But last week, we had the 11th Circuit Court of Appeals review Judge Aileen Cannon's order asserting equitable jurisdiction, and it was obvious to everybody who watched that oral argument, including undoubtedly Judge Raymond Dearie, that Donald Trump is about to lose the expedited appeal filed by the Department of Justice, such that Judge Aileen Cannon should never have asserted equitable jurisdiction in the first place, which set in motion the process whereby the special master, Judge Raymond Dearie, was appointed. So, in short, the 11th Circuit's about to say, this case should never have happened in the first place. Aileen Cannon, you should never have asserted jurisdiction. And if you don't have jurisdiction, then the special master doesn't have jurisdiction. We're shutting down this case. And so what Judge Dearie is doing here is basically delaying right now further work in the case, and he's making the parties do a little bit of busy work while we wait for the 11th Circuit Court of Appeals order, which could take place any moment. And Judge Raymond Dearie, in framing this order, is kind of telling the 11th Circuit here, he's kind of like, hint, hint, can you please issue your order soon, because it's obvious you're about to shut down this whole process that the corrupt Judge Aileen Cannon started. So let me just read for you the order, and then we'll talk about it in a moment as well. The order says, upon further review of the record, the special master has determined that there are no matters requiring counsel to travel to Brooklyn for an in-person conference. The conference previously scheduled for December 1, 2022 is therefore canceled. Instead, the special master directs the parties to respond jointly to the following questions by 5 p.m. on December 1, 2022. 1. Do the parties dispute the categorizations of the following records under the Presidential Records Act, 44 U.S.C. Section 2201 et sec? In each case, the party spreadsheet summarizing their respective categorizations and disputes reflects that the parties have a PRA dispute, despite both sides categorizing the documents as a, quote, personal record. Then it goes on to label the various documents at issue. Question number 2. Do the parties dispute the Presidential Records Act categorization of Bates number, then it lists the document? The party's spreadsheet reflects differing categorizations, but also lists the documents as not being in dispute. Question 3. Does plaintiff, here Trump, assert executive privilege with respect to certain Bates numbers? And it goes on with those documents, and it compares them to other documents. And then it says, noting that there is no further matter to resolve with respect to the other documents. Then it goes, there's a subsequent letter from the government reporting that each document is disputed based on plaintiff's assertion of executive privilege, and it's signed by Judge Raymond Dearie. And so what does all of this mean? Well, what's going on behind the scenes here is that all of the documents, the thousands of records that Donald Trump stole, have been loaded onto a server. The parties are going about making their designations regarding the various records and whether the records are presidential records, whether they're government records, whether they're personal records, and they're classifying these right now. And ultimately, if they dispute dispute it, the special master is supposed to rule with what classification the special master deems to be appropriate. Now, one of the overarching issues here as well that the Department of Justice has pointed out is that Donald Trump should not even be permitted to make an executive privilege claim in the first instance because he's not the president. The Department of Justice represents the executive branch, and a past president can't assert executive privilege to block the current executive branch from having its own records back. And the Department of Justice has also pointed out that in many instances, Trump has claimed records to be personal records because, and this is what Trump said in one of his briefs, that when he stole the records from the White House and shipped them to Mar-a-Lago, he then converted them because they shipped into personal records, and he changed a government record or a presidential record into a personal record by the fact that it shipped to Mar-a-Lago, which is an utterly absurd argument. And one of the things the Department of Justice also pointed out is it can't be a personal record and then him also assert an executive privilege. Those are internally contradictory concepts. If you're saying that the record is a personal record, that it's yours, like it just belongs to you, you don't have the ability to assert the executive privileges. The Department of Justice said the executive privilege is a privilege for the executive branch. It isn't like something that a former president can claim it's supposed to like protect them. And if it's personal, then it's by its very nature not in connection with the duties and services of the work of a president. And in any event, a past president can't claim it. So here, what the judge is just asking them to do is basically a bunch of busy work, going through their spreadsheets and saying, are there real disagreements here? Can you explain the disagreements to me? And they're saying to Trump, why are you asserting executive privilege here? Isn't this like a previous claim where you didn't assert executive privilege? So can you just provide additional information? But the overarching thing that is taking place here, though, is what I said at the outset of this video, which is there was a hearing that was supposed to take place before Raymond Dearie on December 1st. Raymond Dearie heard obviously, he heard the 11th Circuit Court of Appeals argument. Maybe he heard it here. We had the full audio here on the MeidasTouch network. So he obviously heard the oral argument. It's obvious to anybody listening to that Judge Aileen Cannon is about to be overruled by the 11th Circuit Court of Appeals, right? Remember, the 11th Circuit Court of Appeals asked the Department of Justice lawyer how the Department of Justice lawyer would want the order to read that would overrule Judge Aileen Cannon. So if you're Trump and Trump's lawyer and the justices are asking your adversary here, the Department of Justice, how the order should be framed and phrased for the Department of Justice to win, that is not a good sign. And also, you had a number of just preposterous statements being made by Donald Trump's lawyer. It was Jim Trusty, who argued while there was no precedent at all supporting what Judge Aileen Cannon did here, and while Donald Trump shouldn't be treated differently than others, Trusty in the next breath was like, well, he actually should be treated different. There's a lot of exceptional circumstances here, and this is just a general warrant. And so what this whole process is that we should go through this whole process so that at a later time we could determine if the search warrant was valid. And what the 11th Circuit Court of Appeals had said is, look, there is not a single precedent. There is not a single case ever where a judge did what Judge Aileen Cannon did here, where in the absence of any finding that the underlying search warrant being executed was unlawful, or even reached the higher standard of a callous disregard, for a judge like Aileen Cannon to assert equitable jurisdiction has never happened before. This was not an unlawful search. There was a magistrate judge, Judge Reinhart, in the Southern District of Florida. Everybody remember him, who had reached a probable cause determination on August 5th The search warrant was executed by the Department of Justice on August 8th. It was supported by an affidavit submitted by a top FBI counterintelligence official, which provided the detailed facts about Donald Trump's theft of these government records, including top secret, sensitive, compartmented information. The Department of Justice showed up at Mar-a-Lago with the search warrant, followed all of the rules regarding a search warrant that happens all the time across the country, every day regarding search warrants, executed the search warrant, and found the stolen property that Donald Trump stole and hid and was obstructing the Department of Justice in their investigation into the theft of these government records. And so for Judge Aileen Cannon to say she's going to assert extraordinary equitable jurisdiction and really interfere in the separation of powers and block a criminal investigation by the Department of Justice, and she didn't even make a finding. She made no finding of a callous disregard of Trump's rights by the Department of Justice. She so oddly found in her order, she was like, well, Trump's reputation may be harmed as a result of this, and so I'm looking out for his reputation. Like, I'm not making that up. That's actually in Judge Aileen Cannon's September 5th order. Well, the 11th Circuit Court of Appeals isn't buying it. Judge Raymond Dearie's like, I'm going to make the parties do some work. I can answer some of these questions by December 1st. We're not going to hold a hearing. Let's see what the 11th Circuit Court of Appeals does. Let's wait for an order. We expect an order to happen very, very soon. So we will keep you posted here on the MeidasTouch Network when we see the 11th Circuit Court of Appeals order. That order would just completely shut down the entire Judge Raymond Dearie special master process, and it would result in Aileen Cannon being removed from this case because the finding will be that she should never have asserted jurisdiction in the first place. So we will keep you posted when that occurs. I'm Ben Meiselas from the MeidasTouch Network. Hit the subscribe button right now. We're on our way to 1 million subscribers. Also, check out the new MeidasTouch true crime podcast. It's called American PSYOP. It tells the story of General Wesley Clark's son, Wes Clark Jr., who gets trapped in a world of influence operations directed at him, and cults who tried to influence him, and mercenary groups who tried to influence him based on his proximity of power to the former commander of NATO and presidential candidate, his father. It's a wild story. We're on episode 3 or 4 now, but depends on when you watch this. One of the top podcasts on Apple, one of the top true crime and top podcasts of all podcasts on the charts. It's called American PSYOP. Until next time, I'm Ben Meiselas from the MeidasTouch Network.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.meidastouch.com. That's store.meidastouch.com.